4 मई के वायरल वीडियो मामले पर सुप्रीम कोर्ट ने मणिपुर सरकार और पुलिस को फटकार लगाई। शीर्ष अदालत ने केंद्र से पूछा कि पुलिस को 0 FIR दर्ज करने में 14 दिन क्यों लग गए। सॉलिसिटर जनरल तुषार मेहता ने कहा कि सरकार के पास छिपाने के लिए कुछ नहीं है और कोर्ट अगर चाहे तो स्थिति पर नजर रख सकती है। कोर्ट ने पूछा कि 4 से 18 मई तक पुलिस क्या कर रही थी और वीडियो सामने आने के बाद ही कार्रवाई क्यों की गई। कोर्ट ने आगे ये भी कहा कि मामले को सीबीआई को सौंप देना ही पर्याप्त नहीं है।
In fact, the Supreme Court has made it very clear that it's mulling formation of a high-power committee or an SIT, and to which even the Solicitor General Tushar Mehta and Attorney General R. Venkatramani said the government did not have any objection, but the Supreme Court should clearly hear out the government as to what steps it has taken, and the government is also very concerned. That is why a CBI probe has been ordered and swift action taken. Around 7 arrests made and also 7 teams formed to arrest more people. But the Supreme Court was clearly not satisfied, saying that merely a CBI probe will not suffice. We feel the way things are, we feel that we should give some directions as to how you go about it. You cannot be given a free hand, and said that till now 164 statement, that is a recording of these victims and witnesses, of statement of these victims and witnesses before a magistrate, even that has not been done. This incident happened on May 4th, and today we are on July 31st. In fact, more than 2 months have passed, and what were you doing? These were the questions asked by the Chief Justice D.Y. Chandrachud to Tushar Mehta and R. Venkatramani, the government's 2 top law officers. The Supreme Court has listed a series of questions, many of them which we have already referred, and said that the court wants a clear answer by 2 p.m. tomorrow, and only after that the Supreme Court will decide whether to intervene or not. The Chief Justice's words were that if you convince us that you have done enough, we will not intervene. Otherwise, we will have to intervene. Clearly, these are domain of the state government. There is an elected government in Manipur. Earlier, we had refused to intervene, but now situation has changed. Even remember, as you rightly said, it was Kapil Sibal, the senior advocate, who argued for the 2 women victims who figured in that viral video, shocking viral video, and said that these 2 victims don't have any faith in the state government or the CBI, and that is why a number of activist lawyers today, like Prashant Bhushan, Brinda Grover, Colin Gonzalez, Kapil Sibal himself, sought a high-powered high-power committee or SIT, so that they can instill confidence in the victims, not only these 2 victims, several other victims in the state, so that they can record their statements with confidence before a particular committee which will have evidentiary value, and also said that it's a confidence building measure, so therefore the Supreme Court should form such a committee, to which the government said it had no objection to.
वहीं सुप्रीम कोर्ट ने आज कहा कि वो अन्य राज्यों में इसी तरह की घटनाओं की तुलना करके महिलाओं के खिलाफ यौन हिंसा को तर्कसंगत बनाने के किसी भी प्रयास के खिलाफ है। कोर्ट ने पश्चिम बंगाल और छत्तीसगढ़ की घटनाओं के साथ समानताएं बनाने के लिए वकील बांसुरी स्वराज के प्रयास को दृढ़ता से जवाब दिया। बांसुरी दिवंगत सुषमा स्वराज की बेटी हैं।
She said that she tried to draw the attention of the Chief Justice bench to the crime against women in post-poll violence in West Bengal, Rajasthan, and crimes against women in Rajasthan, Chhattisgarh, Kerala, and several other opposition rules said that Lordship, these are also daughters of the country. The orders the Supreme Court is likely to pass in favor of the women victims in Manipur should also be extended to women victims in these states also, and Supreme Court should not turn a blind eye to the violence against women in these states also. At this juncture, the Chief Justice said that there is a difference. There are a lot of difference in the crime against women in Manipur and the states you referred. We are not turning a blind eye to the violence against women in these states. Now, violence against women across the country has become a social reality. But we should note that the violence against women in Manipur is being used to perpetrate communal violence and these are happening in between communal strife and ethnic conflict. That has to be taken note of. It is a graver offence. So and asked Bansuri Suraj whether do you want that the Supreme Court should turn a blind eye towards all daughters of the country, or should not, or the Supreme Court should pass orders in favor of all daughters of the country. So you should decide, and you should not make such comments. You cannot compare the crime against women in Manipur and other states. There is a clear-cut difference, and that does not mean that we are ignoring the crime against women in these states, as you mentioned. And in fact, Bansuri Suraj was arguing for two interveners who had appeared from West Bengal. They in fact cited several acts of violence against women, including the disrobing and sexual assault against Panchayat BJP Panchayat poll candidate. But Supreme Court refused to encourage or admit this intervention application and said that a wrong picture is being tried to be portrayed by Bansuri Suraj.